And we're live. It's Wednesday. It's a lovely day in Alberta, another summer day in this lovely province. Chris, we're going live. It's going to be a fun show tonight. It's Alberta Shop Talk. I'm your host, Mackenzie Wilson, alongside Chris Noble. Chris, how you doing?
Very good. Yourself?
Good. A little bit of last minute craziness with a babysitter and my kids. They are definitely giving her a run for her money. But I have removed the noise from my office. I think I'm gonna be good.
Do you have to take a stress drive?
Well, actually, I tried to do the show in my car. I thought it'd be a lot more less interruptions. But I realized I couldn't start the show from my phone, so I was running back in, and we're getting organized. So, but really excited for this show tonight. We got two lovely ladies lined up. Our first guest is Jillian. This is actually your guest, Chris, so maybe I'll let you run with the introduction.
That's right. Jillian is joining us from, she's a insolvency trustee, but she works with Myers Norris Penny. And her and I just met just 2 days ago, just by coincidence, because I was checking a comment on another page. And I was digging back into my background where I used to do some financial work and deal with bankruptcies and whatnot. And it was a situation where a landlord wasn't giving back some of the money. We'll get into that a little bit further. So that led me to call Myers Norris Penny, because they're locally here in Red Deer. And I connected with this lovely lady, and she was so accommodating to me. I said, you know what? We got to have her on our show.
We're going to learn so much. I know nothing of the subject. So like you, Chris, I think I'm going to be glued to listen to what she's got to say. There's going to be a lot of great takeaways for landlords, especially if they're dealing with a bankruptcy with a tenant and there's money owed. How do you pursue? How do you protect your position? You know, what things should you be asking for? There's a lot of questions we'll be asking tonight, and a lot of great takeaways. The second part of the show, we've got another local landlord coming on the show with us. She's a bit of a power couple. So she's an investment-focused realtor, and then her husband is a general contractor, and they have a bunch of suited properties here in Calgary. I'm not sure the number of doors. Don't quote me on that, but they've been busy for a while. I've met her through a few different real estate meetups. Her name's Terrin. She's going to be phenomenal to talk to, and she's got a really good conversation around, if you are looking for a rental property, how to look at those numbers, what to look for in the properties, just to set yourself up right. So again, another good conversation. And of course, as always, we'll be taking your guys' questions live. As well, we've got some queued up too that we'll answer as a landlord panel. So I guess without further ado, let's get Jillian on the show and take it from there.
Excellent.
Good
Jillian,
evening. Hello.
How's it going?
Good. Thank you for having me, Chris and Mackenzie.
Awesome.
You're very welcome.
We're very stoked to have you there. Like we said in the kind of the pre-show there, I know nothing of the subject of bankruptcies and proceedings and who's got rights, first dibs and monies and owed and all that sort of stuff. So from a landlord perspective, there's gonna be lots of learnings here, and yeah, we're kind of thrilled to have you in the show. But how about you maybe throw in anything I've missed? I know we gave a very brief introduction, so give us your 30-second elevator pitch on who you are.
Okay, my name is Jillian Anderson. I work for MNP in Red Deer, and I specialize in consumer insolvency, so bankruptcies and proposals of people like you and I, not necessarily corporations. I have been in the insolvency world for about 18 years. I am a Canadian insolvency restructuring professional, and I am in pursuit of my LIT, or Licensed Insolvency Trustee designation. Yeah, so I'm honored to be asked to speak, and I will share with you as much as I possibly can and ensure that I deliver as accurate as possible information. Disclaimer, I am not a lawyer, so I can't give legal advice. But with a lot of experience, we've seen a lot of things in the past and loopholes, if you will, just about things that can ease the process for someone who is blindsided, per se, by a bankruptcy, or even someone having to file a bankruptcy. So I'll do my best to answer the questions the best I can.
Yeah, totally. I mean, we'll work with you too. Like I said, it's all learning, even general information. I don't think many landlords have dealt with bankruptcies, and if they have, it's, like I said, it's not a very common thing. But if it does happen, I mean, where do you start? There's a lot of questions that, yeah, we know where to go with. So maybe Chris, how about you start us off with how the conversation started? I know you have a situation that you guys are discussing, and I'm going to sit back and listen to the conversation.
It's going to be a different night tonight, isn't it? Yeah. So, you know, I think this is a very actually timely conversation to have and topic because of the, you know, the present COVID situation, the economy in Alberta. There's a lot of stuff going on, and I'm sure, Jillian, you've all of a sudden seen your workload get a little heavier. So I think what would be a great thing to do is, because we're really focused on landlords and their properties and stuff, we'll kind of maybe gear it around there and branch out where we have to. But because we focus our group on you know, helping landlords run, you know, a business, let's go down that road. So
okay. So when an individual files a bankruptcy, there is a stay of proceedings that takes effect, and that becomes, it's a legal barrier between the person filing that needs the protection and the creditors. So it's an automatic stay, and it prevents all creditors, including landlords, from pursuing the repayment of debt. In saying that, landlords are afforded a priority when it comes to a scheme of distribution from dividends that are collected while somebody goes through a bankruptcy. And they're afforded a priority over other creditors for past rent and accelerated rent. So I'm going to go back to the question that kind of connected Chris and I. He was actually asking, with a security deposit being paid to the landlord when you rent from them, it should be held, I believe it's like provincial legislation, in a separate account that's interest bearing. And if there's no damage when you move out, it's to be returned to you. Now, if the landlord goes bankrupt, although they should have held that money in a separate trust account, if you will, if it is not held there, there is little recourse for the tenant to actually recoup the money, basically. We talked about, because the stay of proceedings puts that legal barrier between the creditors and the person that's filing, the only way that you can pursue them for that debt and not participate in the bankruptcy is to apply to have that stay of proceedings lifted. Now, in order to lift the stay, okay,
I'm just going to interrupt you for a sec, Jillian, because one thing is, I understand, because I'm in the legal, have a legal background, and I understand some of the terminologies and having some credit background as well, experience. But when you talk about a stay of proceedings, right off the bat, watching TV, we think, oh, something court, the guy's getting off on his criminal charges. What does a stay of proceedings mean?
So a stay of proceedings is a legal barrier that halts all legal action that is currently in place against an individual or a business.
For example, I'm suing somebody because they owe me money. They're saying, well, I haven't got any money to pay anybody. So they go see you and you go, stop, nothing more can be done.
Correct.
And you're sending some paper out. I receive a paper and it says, you can't do what you're doing anymore.
That's exactly what happens. Yep. When somebody makes an assignment in bankruptcy or files a proposal, that stay of proceedings is automatic, and you would get a notice being a creditor. And typically you would call the trustee and find out what your rights are. In that package, it's called a creditor's package, and it also includes a proof of claim form. And that is what the trustee requires somebody to fill out to prove that you were owed money. So for the instance where that security deposit is being held, you would be listed as a creditor, hopefully disclosed to the trustee that you owe that person their security deposit back. And you'd be listed as a creditor, and you'd be sent that Form 31, the proof of claim, and you would then have to attach documentation to show the trustee how you're arriving at the amount that is being claimed.
Okay.
Yes.
Can I ask a couple of questions too? I'm a little thinking things through here. So let's, before we jump in that situation, I know you mentioned that landlords get a slightly higher priority when repayments are going out to the different people owed, for lack of a better term. Can you kind of give me an idea of what that scale looks like? Are we in the middle, to the top? who are we up against, I guess, when someone goes into bankruptcy?
Yeah, and what do you mean by priority? What does that mean too?
Okay, so there are a number of types of creditors in a bankruptcy. There are secured creditors, like mortgage holders, banks, people that have your vehicle financed. Those guys are considered secured creditors, which means they have collateral or something that they can go and take from you if you default on the loan.
Okay.
There are unsecured creditors, which are overdrafts and lines of credit that don't have any collateral attached to them, MasterCards, or arrears owing to a landlord, or legal fees. Then there are preferred creditors. So somebody who is owed child support arrears, they are a preferred creditor for 6 months arrears owing to them. Now, when we talk about landlords, this is in a commercial kind of situation only. Unfortunately, just a regular consumer, there is not a lot that is protecting a landlord from being set apart from the other creditors when somebody files a bankruptcy. If it's a commercial lease, that's when they end up being able to be, I guess, given a priority over all the other creditors when the trustee is going to distribute money. Now, what they're entitled to is 3 months rent arrears, so 3 months worth of rent owing prior to the date of filing. And they're also allowed 3 months accelerated rent if it's provided for in the lease. So a total of 6 months worth of rent. Now,
and we're talking commercial.
This is commercial. Yeah, this is a true lease. They're basically the only ones that are afforded that priority, and only the proceeds that come from the sale of the assets that were in that premise.
Okay.
So
you're talking like a mom and pop's fishing shop that goes sideways.
That's
commercial
right.
leases, yeah, business like business properties.
So, right. So they go, they have a fire sale, they get a liquidation sale, everything gets sold, and that all that money gets distributed accordingly.
To the landlord first.
Right.
Yeah, before it goes to anybody else in the bankruptcy. Now, there is so much to know about commercial leases and things as far as the landlord's rights when a trustee or a receiver is appointed. Basically, the trustee steps into the shoes of the person that was renting from them, like the leasee. So you cannot modify any agreement that was already in place. So if the lease was $3,000, it stays at $3,000. The trustee has 3 months to either disclaim, assign, or terminate leases. And if a trustee is going to occupy the space, whether we're going to have an on-site auction or just need time to get books and records out of the building, those must be paid from the trustee from the day that we take possession of the property. In the court order, it allows us to change the locks and basically protect the assets in the property until they've been liquidated.
So let's spin this around a bit. So most of this audience, if not 99% of it, we're all, small residential landlords. Maybe some of us might be multifamily, but we're all in the space of renting to just general tenants, people looking for a place to live.
Right.
So if a landlord's getting pulled into a bankruptcy, maybe by their tenant or on one of their properties, what could they do to help strengthen their position?
Okay, so there's a term, it's called reaffirmation of debt. So like a dentist, if you have braces on and you want to continue to see them for your braces, you generally maintain that debt. If you were in a legal battle for custody or a divorce, it's a debt owing to the lawyer, so it has to be disclosed. But if you want to continue to use their services, then you will agree or make some type of arrangement with them to continue paying. So the same thing kind of happens with landlords. It costs people money to move, and quite often they do owe 1 or 2 months worth of arrears to the landlord. They haven't been evicted, but some notices have been sent to them to say, hey, you owe us the money and we need to make arrangements here. So if the person that's gone bankrupt wants to continue to stay in the building or in the suite, an arrangement to pay the arrears so they don't get evicted can be made outside of the bankruptcy. So if you're
does that have a lot of weight or priority compared to what's the other parties inside of part of that bankruptcy?
So it would be an informal agreement between the bankrupt and the owner of the property to, pay $200 a month more than their actual rent to go towards the arrears. But that's nothing that the trustee is going to be able to help that tenant with. They need to make a clear decision whether they're moving out and the debt is being included in the bankruptcy, or if they want to stay and make arrangements with the landlord to pay it.
Okay, so if they do make some arrangements on the side, that could remove that debt owing from the bankruptcy claim, or
essentially, yes.
Okay.
Yeah.
Interesting.
So let's go to back to that question. So the scenario.
Can we get an Can we get an overview of the scenario? Because I'm not even up to speed on it, so I need to know. Because is it a tenant or is it a landlord that is in bankruptcy?
So the scenario is that we have a landlord that is going to declare bankruptcy, and the tenant has moved out. The tenant has moved out, left the place in proper order. Everything's great. Now they want their damage deposit back. In this case, the landlord says, "Sorry, I spent it. I'm going bankrupt. I can't pay you." So this is where Jillian and I met on that exact scenario. So,
interesting. Okay.
So we're kind of trying to help out a tenant, I guess, to some degree, but at the same time, help that landlord, because I'm going to touch on some things that Jillian and I talked about. She's going to give her point of view, and I'm going to give a different perspective on it and see where there's some middle ground here. Go ahead.
I love it. I need my popcorn.
Okay, so there are, so under the bankruptcy and insolvency legislation, that's where all of the rules and guidelines and everything come from that we follow and administer. There is a section, it's section 178, and that is debts that are not released by order of discharge. So those, they're very specific on things that will survive a bankruptcy. Student loans less than 7 years, for instance, are not dischargeable. So they're included. They would get a dividend, but if there was a balance owing, they would still owe it. A fine, penalty, or restitution order that's been granted is not dischargeable. So that's where Chris and I were talking about, I guess, something that a tenant could do to get back their damage deposit after leaving the suite in immaculate condition is they could make an application to lift the stay. They would need to do that with counsel because you're unable to self-represent in the Supreme Court, as we understand it. But if they can make an application to lift the stay and prove that they will be materially prejudiced if the courts do not actually agree to lift the stay and let that tenant pursue the landlord, it can be done. And then they would end up with a court hearing, and I mean, their hope would be to turn the damage deposit into some type of restitution repayment or a fine if there is, such a thing.
Okay,
I need some English there. I'm so confused. So
yeah, I picked up on that. I'm going to back you up because we got to get in. We got to do layman talk because you got us two guys and there's more of us out there.
Okay.
So you're saying we can apply to a court to have it set outside the bankruptcy so it doesn't. Okay, so do you represent the creditor or the debtor when you do your job?
We represent the creditors.
Okay, so the tenant is a creditor in this case.
Right.
Would you represent them and bring that forward on their behalf?
We would not, no, because we're administering the bankruptcy and insolvency legislation. And basically the landlord has gone bankrupt for a reason and they're insolvent. The definition of insolvent is that they owe more than $1,000 and cannot pay their debts as they come due in the normal course of business. So they've rightfully assigned themselves into a proposal or into a bankruptcy. And I mean, the trustee would have no reason to make an application to lift the stay. That would be done by a creditor.
All right, and what does that last part mean? Lift the stay? I didn't.
To lift the protection that's been placed.
Oh.
Yeah, so then no legal action can be continued. Yeah.
Okay.
So no, that would not be an application that the trustee would help them make. But I mean, if a creditor phoned us and said, "Hey, how do we go about doing this?" We're obviously going to, tell them kind of what I'm telling you. you know, you would have to look at how much is that damage deposit. Is it going to be worth it to hire counsel and go to court and try to pursue this $1,000?
Well, that's a good question. Where is the starting point? Like, what should people expect if let's say $1,000 is a great starting point? Is that even worth chasing in this kind of a scenario?
Yeah, okay.
So if I was a tenant and I knew something was coming down, if I knew ahead of time, I would just dig my heels in and stay an extra month and not pay. At least you get your value of your damage deposit.
Definitely a good idea.
And because even though you take over, okay, so this is another portion. I need to still get into my little angle here, but something a landlord wants to know: you have your principal residence and you have your rental properties. Are you allowed to keep your rental properties, or is the equity in that going to get thrown into the place be forced sale and thrown into the pot here?
Well, a trustee does have to go through all the assets of an individual and make sure they are afforded some exemption allowances under the Civil Enforcement Act in Alberta. They are entitled to $40,000 worth of equity in their principal residence. So exactly that, Chris. If they have a principal house that they live in and a mortgage and they have a fourplex, that is not considered their principal residence. And then we look at what is owing on the property versus what the property is actually worth. So if the property is worth $400,000 and there's a $300,000 mortgage, the trustee will be looking at realizing on that $100,000 for the benefit of the estate. Now, that does have to be paid into the bankruptcy in short order. Bankruptcy can't go on for, indefinitely. So typically they'd be looking at getting a refinance, and quite often they're going to have to sell their property.
Right. And so the proceeds of the sale come into the trustee because you're in control of everything. And right. All of a sudden creditors and whatnot are getting paid off. So
exactly.
So It's not always a good choice, this bankruptcy. If you own properties and you have a business, not always a great choice.
No. But you know what? That is what we determine in the consultation, which is free. And we go over basically the cost of it all, what you're prepared to lose, what you can afford to keep, credit ratings and such. One thing I want to say is whether or not if a proof of claim is mailed to you or faxed to you by a trustee, for you to participate in the bankruptcy process or the proposal or restructuring, you have to prove your claim. So even if you are going to want to explore lifting the stay and pursuing them outside of the bankruptcy somehow, getting a provable claim filed with the trustee will keep you informed of everything happening on the estate.
Right. So you have a rental property and it's got $20,000 of equity. After real estate fees and lawyers and everything, there's maybe 10 grand, 5 grand left over. You could still force the sale of the house and bring that money in. Is that correct?
We could. That's not usually the position that a trustee takes. If somebody is making an attempt to get that equity paid, we're not going to go in and try to force a sale. But okay. I mean, it does happen. Yeah.
Now, I want to throw in my angle on this now, and we'll see what you think. So a little bit of research, and I actually talked to a prosecutor about an hour ago because he's a friend of mine, and came up with, under the Residential Tenancy Act, there are several positions here saying failure to deposit a security deposit into an approved trust account, failure to ensure security deposits remain in a trust account in accordance with the Act, and and fail to keep records of it all. So there's quite a bit of thumbs on the landlord here as to what they can do with their money. So each one of those under the Residential Tenancy Act, there's actually it's a ticket. For simple terms, for the police, it's actually just a ticket, a Part 2 ticket, right out, just like a speeding ticket you get on the highway. If you're going over 50 kilometers an hour over the speed limit or more, 51, you get an appearance to go in court. In this case here, the fines are like $280 to $400 on some. Once they're forced into court by the investigator, and they let's say they have a trial and they're found guilty, or they're going to plead guilty, you as myself, let's say I'm the tenant, I can go and I can ask for restitution. And ask the prosecutor, under the provincial end of things, can restitution be ordered? He said absolutely. So a restitution of $1,000 damage deposit now is ordered on top of the fine the guy just got. So if he just gave, he had, he's $300 to good on the fines. He only had to come up with another $700. But if you do the math on that, in this case here, if they get the fine and restitution is ordered, how does the restitution play into your world?
So the person would file a claim and provide us with a copy of the restitution order, and we would admit their claim in the bankruptcy. And whatever they wouldn't get or don't get from the bankruptcy, they can still pursue the bankrupt outside of the bankruptcy or once it's finished. So,
right.
Yeah.
So with that said,
so are you, Chris, I want to make sure I'm understanding. You're saying if I am the landlord or the tenant going after the bankrupted party for money owed, that you'd go through the RTA legislation?
No.
No.
Oh, yes. Sorry, keep going. Yes, it's the legislation. It's the Residential Tenancy Act.
Because there's two. Well, there's two. What's the right words for it? Bodies of law or legislation at play. There's the sorry, Jillian, the insolvency.
The federally legislated Insolvency Act. Yeah. There's
that act, and then there's obviously provincially where we're mandated underneath is the RTA, the Residential Tenancy Act of Alberta. So, does a tenant or a landlord have to make a choice on where do they file their debts to get made, or do they go into both acts?
No, two different worlds.
Yeah, but you would disclose. So if you knew that the landlord was insolvent and there's a trustee appointed, when you're making your case or your application under the provincial legislation, you do have to bring to the court's attention that this person is in bankruptcy and that there is a stay of proceedings in effect. And then the trustee would be served notice of that application. And we don't usually dispute or agree to lift that stay. It's completely up to the court's discretion.
Right. So in this case, what happens? The police would go and write out their little ticket and give a court appearance to the landlord, and you as the tenant, if you're the one that's been slighted by him or a victim of the circumstance, you'll go in and you'll say, well, I would like the courts to order me restitution. He's pled guilty or found guilty. So the courts say, well, how much is that? You'll have your documentation. It's, for argument's sake, $1,000 that he owes you. Then there'll be a restitution order for $1,000. And now that's where this court over here has taken a position, and this legislation over here, being the bankruptcy, they're going to see what do they have to say, and now you have to honor what they say, because now you have a restitution order which steps everything outside of what you're doing. Am I thinking about that the right way, Jillian?
Yes. Yeah. So once somebody has a restitution order, they can pursue the bankrupt, even inside of the bankruptcy, while they're protected. The trustee just needs to be aware of it. So, you know what, one of the things that you touched on was basically the landlord and their misuse of trust funds, them not putting it in that segregated account. That would be grounds for somebody to oppose a bankrupt's discharge. So that's something to keep in mind as well, that if you were unsuccessful in lifting the stay, or you didn't want to go through the process of doing that, you can still have your say or your day in court to say, you know what, I feel that I've been materially prejudiced. This should have been held in trust. I did everything properly, and I want my money back. So you do have an opportunity to kind of ride on the trustee's discharge application of that bankrupt to be able to have your say to the judge, basically.
Certainly easy to see where people will go, all right, I'm done with this, and they just wash their hands of it. But if you're persistent, you push through, there is a light at the end of the tunnel. I've had the opportunity of working in the law enforcement world. You're in the financial part of the world, and here we sit down and we have a chat and we say, well, yeah, actually, if we put our heads together, there is kind of a system in place. Then we have our poor people that kind of don't know either. They're going like, what do I do? They just give up. So it's tough. Thank goodness we have these kind of shows where we can at least get these seeds planted and people can start digging.
One thing I'll say is when somebody files a bankruptcy, you get what's called a statement of affairs. So that says, it tells you everything that they own, what it's valued at, how the trustee or the person valued it, because we have to verify that it is a true value. It talks about what their income is and if there's dividends expected in the estate. So right on the first page, you'll be able to see, is there equity in that fourplex? Do they have a boat? Do they have, like, is there even going to be any realization for the estate after everything is liquidated? Whether it's worth it to pursue a court or a restitution order against them. If there's no money to get, there's no point in spending more money to fight it. So I would say you can always contact a trustee directly and say, hey, can you just look at this and see if there's even a dividend coming, or can you help me make sense of this? And a trustee would, I'd say 100% of the time, educate you or walk you through it.
So what are your thoughts when I show up out of the blue talking to you? We're not even talking about a particular case. And then I throw this Residential Tenancy Act and these fines in this scenario to you. Like, what's your spin on what I brought to you?
You know what? It's provincial legislation. So if you can take it as far as you can and actually get a judgment or a fine, I'm in support of you filing a claim. There's really nothing that can be done against the bankrupt that does have protection. That's the point of a bankruptcy, right? Is to protect them against their creditors. And, when you said, oh, they could just pay me the $1,000 and all this goes away. Well, there are offenses in the bankruptcy legislation that prevent somebody from preferring one creditor over another just because it's a mother or a brother or a great landlord. So the trustee will go and claw back any monies paid to just one individual that was preferred over everybody else. So you know what? Most people want to pay their debt. They just can't. There's not enough money to pay everybody, right? So you talked about one tenant. What if they have an apartment building with 7 people that just moved out, and it could be a lot bigger than just that $1,000. But it is not good news when somebody goes bankrupt. I must say, yeah.
My takeaway is I'll be calling someone like yourself, Jillian, to make sense of this, because there's a lot of moving parts at play that I just are a little over my head. So I mean, if you don't know, you got to find the right professional advice.
So my angle on it versus and Jillian's angle, there are two different perspectives. Mine is that something illegal has happened, and that's what the avenue I would pursue as a tenant or a landlord, whichever. And Jillian's angle is that she's going to protect the debtors against the creditors for or the insolvency end of it. And then somewhere in the middle, these two ideas can meet and be successful.
Absolutely.
Yeah. Well, there you go. We have another guest coming on, and I know we can overwhelm everybody with this topic, but I think we got some simple facts out and got them simplified. So really appreciate you coming on tonight, Jillian. This is really cool. So
yeah, absolutely. I would, if you guys have other questions, feel free to reach out, or any of your listeners, if they've been hit with some documents or they don't know how to make sense of it, or have questions, it's always free to call. So
and so where do people get a hold of you, Jillian? Because there's lots of people watching, and we get hundreds of viewers after the fact. If someone needed to get a hold of you to chat with you and discuss an insolvency issue, where could they reach out to you?
So corporately, they can call us at 310-DEBT, and it'll ring to the closest trustee's office to your location. And if you want to reach me personally, you can call me at 403-356-1264.
Great. You're at the Myers-Norris Penny office in Red Deer, correct?
I am. Yeah, right downtown.
Awesome.
Working from home, though.
yeah. Well, welcome to the club. But yeah, totally. Awesome, Jillian. Super informative. I'm going to have to rewatch it again just to follow some of the lingo, but there's some great information, tips you provided us. So thank you.
Thank you for having me.
Thank you very much. And have a great evening.
You too. Goodbye.
Bye-bye.
Okay, cool.
Wow, that was really cool. So
yeah, that's a whole nother world I'd never even given thought to, but it will cross the path every once in a while with landlords and tenants, right? So
we got another guest in the wings. This one's an exciting one. Let's have building our futures here. So here we go.
Absolutely. Let's get Terrin online. We'll get her going. She's got a great conversation for us as well, and then we can dive into some of the questions off the last week on the Facebook group as well, folks. If you've got questions right now, we are a landlord panel. Throw them out there. Let's work together, brainstorm. We can find some great solutions for you out there. Okay, Terrin, I'm bringing you on now. Hey, Terrin, I got you online. I think you're just muted, so if you take off your mute, you should be good to go. Can I do it?
There you are.
You're good. There you go. So welcome.
Thank you. I'm excited to be here. Thank you for having me.
So you got to watch the last show. What did you think of all that information?
It was a lot to take in.
It was, yeah. It's hard to dumb it down in 30 minutes, but wow. I'm excited to hear what you have to say, and Mackenzie's going to lead you through this one and hear about building and making more money. So
yeah. So I've known Terrin. We've met a few times through some different real estate meetups here in Calgary. I kind of refer to her. She's like kind of the power couple. She does the realtor side and the investment side, and then her husband, Adrian, is a general contractor. So you guys make kind of a really unique pairing. And when you go and speak with clients looking at investment properties, so we do see quite a few questions on the page, and people are saying, "Where do I look? How do I invest?" You've got a really good take on the numbers, right, Terrin? So. Yeah, I think it'll be a great part for the last part of the show to kind of change gears a bit, definitely from the first part of the conversation we had. But how about for folks that don't know you, and if I've missed anything, give us your 30-second pitch or introduction.
Okay. So as Mackenzie said, I'm a Calgary real estate agent. My background's in marketing and design, which has helped a lot in my real estate career. Just bringing that to the table, as well as being married to my own version of Mike Holmes. So I like to joke about. I used to say Tim the Toolman Taylor, but he's like, he doesn't make mistakes like that. So
Oh, yeah.
Mike Holmes, because he literally knows how to do everything and he just does it all. It's really impressive. So we have either built or renovated all of our suites that we have here in Calgary. We currently have 8 doors. Primarily in the southwest and southeast area. They're almost all up-down suites, just because that's what we find is the most profitable and the most cost-effective to purchase into, and then get the most monthly rent from them.
Cool.
So this little spiel.
Yep. Yeah, so I know we kind of talked about earlier today when we're kind of gearing up for the show there. You're kind of talking about a lot of conversations you're having with folks right now when they start looking at investment properties. So I think you made some really good points there talking about, one community versus another community. Well, maybe the rents might be the same, but you've got different purchase prices. So do you want to kind of shed some light on what you're kind of explaining to me earlier?
Yeah, absolutely. So, I mean, I work with a number of clients, whether they're looking for just strictly investment-based properties where it's only a rental, or some of them, they will want to live upstairs and then, rent the basement out, which is also a great way to have a mortgage helper. Mm-hmm. So, I mean, that would kind of determine, what your preference of where you want to live. But if it's strictly an investment purchase property, then kind of my go-to areas are Dover, Forest Lawn, Southview, Ogden, Erin Woods, kind of areas like that. Mm-hmm. Find that the investment cost is a lot less to get started in, and then the monthly rents are still, pretty comparable to some of the nicer areas in the city. But that way, you're maximizing your cash flow and making the most money that you can off of that monthly rent. So those are kind of my go-to spots. They're close to downtown. They have easy transit access because a lot of long-time renters need that transit access. So
and you open yourself up to a bigger demographic, right? So if you've got people have vehicles, they can generally live anywhere as long as they're close to the places they want to commute to. But if they don't have a vehicle, well, then they're very restricted to public transit, arteries and whatnot. So having both those amenities close to your property makes it easier to rent when it's good times, and then even in the bad times as well. Plus your rent's a little bit more stable when prices are declining.
Yeah, absolutely. And other things to look for is just, the care that people look at, like the care in the property that their neighbors have too, right? Like you don't want to go in a total sort of rundown neighborhood where you can tell that people just don't take that pride. in their properties. So if you do invest in something that has, neighbors that are owners as opposed to all tenants, then usually the property will hold its value a little bit more than, just primarily rental neighborhood. So
Okay.
that's kind of the first thing that I look for is what is the area. And then second thing I look for is the property itself. So whether it's a detached or a semi-detached, I look at both of those. But mostly the square footage is how big is it? Anything under 800 or 900 square feet is usually a little bit too small. Like it won't rent as easily. Primarily the target would be 1,000 square feet plus is great because then you have space, right? Like you want to make this as appealing to rent as possible. So that's one thing that I look at. Things in the 700s they're a lot smaller, especially when you're trying to get 2 bedrooms, which is probably your most profitable market. It'll just be too tight. So
yeah, for sure. And I just kind of want to add to that. When you look at rental rates out there, the biggest things that change what you can charge for is number of bedrooms, and comes first. Then second place is number of bathrooms. Whenever you measure stuff, that's really comes down to. So having the ability to have an extra room, a 3-bedroom over a 2-bedroom, makes it that much easier to rent and charge a little bit more.
Yeah, absolutely. So square footage is important. Then things like, does it have a garage? Because you can always rent the garage separately. So that's an extra maybe $200-300 a month, depending on where you are. If you don't want to rent it to the tenants. So just a little extra money there. Does it have a yard? People do like to have backyard space. So if they have a family with, maybe 1 or 2 kids, a yard space, it definitely can increase your value a little bit for sure.
Cool.
Next thing into like the property itself, I look for is like the bigger ticket items. So things like windows, the size of the windows. You can always add a window in, but of course there's going to be a cost with that. So if the property already has egress windows in the basement, then that can save you a couple grand per window in your overall investment. So that's
if you had someone new and they're with your husband's kind of contractor, right? I know you've probably picked up a few tips and tricks over the years. If someone's coming in and they're looking for good bones that make a property easy to legalize, what would be the key takeaways that we should be looking at?
Well, right now there's an amnesty period for grandfathering in a pre-existing suite, which is a little bit easier to do than a new suite because there's different codes that you have to follow for building a new suite. So it just costs a little bit more. So if you can do it during that amnesty period, definitely get it done.
Yeah.
But yeah, so things like the size of the windows, like that's probably going to be one of your biggest costs is, say $2 to $3 grand a window that can add up quick if you have to add in, 2 egress windows in either bedroom.
Yeah.
And then of course you want to have as much natural light in the basement, just so it's easier to rent and more appealing to rent for potential tenants. So it can add up quick. So that's one thing I really look for right off the bat is the size of the windows. And then types of flooring that I look for. Is it something that's going to be easy to clean and maintain? So something like a laminate or a vinyl wood versus a carpet that will just wear better and be easier to maintain when you do have tenant turnover. So that's something I look for too. And then of course, like the condition of the home. So does it just need cosmetic fixes like paint, little things here and there, or does it need a full on like reno sort of gut job to get it to a renting condition?
Perfect.
And for Adrian Tandy, of course, to come in and kind of give a walkthrough and just give them, a rough idea of cost, just so they know right off the bat, okay, well, this is going to cost this much to get it up to this level.
That's huge. That's really huge too. I just kind of want to add on from personal experience. I've gone in now and some of my properties I'm doing maintenance I didn't really foresee. So now I've got to be a little bit sharper with my reserve fund so I don't put myself at risk. But yeah, if you can have a really good idea when you go and look at a property and what you need to do, also it makes it a lot easier to plan accordingly with your funds.
Yeah, so he's done that, many times with my clients. Gone through a walkthrough and just given his opinion, kind of done even like a pre-home inspection just to see any red flags that we were like, oh, this is just, it's too much, and they don't even go through with the conditional offer, like the conditional sale, sorry. So yeah, it's really helpful to have him there with me to be able to
Perfect.
give that value to my clients.
Yeah, I think I was just gonna think and add into like that short list. Like for sure, windows are a big ticket item. You know, if you don't have if you have a false ceiling, to legalize in Calgary, it has to be drywalled and sealed. So you actually have to drywall the whole ceiling. So I know I was looking at one property and I got talking to a couple other investors, and I realized when we got talking about the different requirements that I didn't include on that ceiling being done first. So I went back and changed my numbers, and I was like, well, that's a couple more grand right there, right? Because the procs got priced, and then you got to have boarded and then mud and taped and a couple coats, right? So
For sure.
yeah.
Although at that point, if you can get it for the right price, then you can add in soundproofing between the levels, right? If you have to do the ceiling anyways, you can add in the soundproofing, resilient channeling, thicker drywall, so then you can actually sell it as like a soundproofed or more soundproofed suite.
Yeah, and I can't like so I've got 6 doors. Two of them are pre-existing, and one we doubled up the drywall and with some acoustic barrier and whatnot, and noticeably different. And I just think from a time savings in the future from being a landlord and having to deal with complaints, if the tenants hear less of each other, there's gonna be less complaints and there's gonna be less phone calls to you, and you're gonna have your time it's gonna respect your time a lot more. So I mean, that's something to do today if you're looking at long-term investments, that you can just have less challenges or headaches to deal with, make it more streamlined in the future. Definitely the soundproofing.
Yeah, absolutely. It's for sure a selling feature that we include too. So the suites that we build from scratch, we've included that, and it's well worth it.
Yeah. Cool. I love it. Awesome.
So Terrin, you have a fan.
Pardon?
You have a fan. Mike Morrow. Mike Morrow. Do you know him?
I do. Yes, he's a client of mine.
Well, he's already put a plug on here for you guys. So I thought maybe I should just make mention of that. So you can probably see that comment yourself over on the right-hand side. If you click on where it says private chat and comments, if you click on comments, you'll be able to see it at the bottom there. So.
Oh, yeah. Well, thank you. I appreciate it.
Yeah.
So,
all right. Should we tackle some questions, or do you got anything else you kind of want to throw in there, Terrin? What's your thoughts there?
Yeah, just a couple tips for after you purchase your property. Just wanted to give a few sort of tips and tricks that we've learned along the way.
Yeah.
So all of our suites, we have painted the same color. So it's called doe skin gray, so it's a nice neutral gray color, and it just keeps things easier because we know exactly what color it is. We don't have to go fishing through 10 different types of paint. It's modern, it looks nice, and we know exactly what it is. So it's always the go-to one. So that's just one tip that we do with all of our suites.
Cool. So same color scheme through all your properties. So you're not, I love it.
Yeah. I totally got into that just by default, and then I said, hey, this makes sense. So here's somebody else's, and mine's Riviera Pewter, and it's a Riviera Pewter gray. It's just kind of a gray, and I just go down to the store and I said that one on this. I go, we know which one, and they'll either mix up 5 gallons or 1 gallon, whatever.
Perfect.
So that's a great way to keep life simple. So
totally, you don't have to have 10 different gallons of paint to be like which one goes where. It just keeps things easier. So
oh man, I've had so many gallons of paint up until I got that figured out. I wish we had met sooner. I have every address written on the top of the can and which rooms and we were used in. I'm going, this is ridiculous. So
just trying to keep your head on top of all the different paints. Yeah.
Another thing is, if you're just taking possession of the property, once you get it to 100% rentable condition, spend a couple $100 and just get professional photos done. Like, they will make a world of a difference in the long term. Say $200-300, you have professional photos. They're going to be more appealing to tenants, which just gives you more of a selection to go through them and just really screen them and get the best fit for your suite. So I highly recommend that to my clients.
I did that in July. Yeah. Yeah, I'll throw one thing on there. I 100% agree with the Terrin. Like, man, like when people look at an ad, they maybe read the first sentence of the description and then they're down to the pictures. Like, click, click, click. Okay, this looks nice. I love it. And then they go back, and it's really what pulls people in. If you're doing a suite property, I use my realtor's photographer. And then when I was talking to her, I was kind of explaining what I was doing. They actually gave me a discount because I just did photos of the main level. I had it repainted and did a bunch of work, but I still had tenants downstairs. So when they price you out, they typically price for a full house. But if you say, hey, you know what, I just need I don't need outside pictures. I need the pictures of the, the 1,000 square foot main floor, they might be able to give you a cheaper price. So a question worth asking.
Yeah, for sure. Absolutely. I mean, there's lots of great photographers out there. Lighting makes a huge difference. So you just want to make it the most appealing as possible to potential tenants. It's the same idea when you have a property listed on MLS, right? The better appealing the photos, the more eyes you're going to get on it, then the more people are going to go and do a showing and potentially have a buyer or a renter. So
yeah,
absolutely. And then after you have the photos, we always are very organized with our ads and our photos. So we number them from 1 to 10. So we know exactly, we don't have to go through them and start scrolling and be like, which one's first, which one's first. From 1 to 10, you just grab them all, upload them, and copy and paste your write-up. And it's just easy to have it, postable onto Kijiji right away. I know that Rentfaster and Marketplace will actually store it, but for Kijiji to always kind of stay at the top, you have to keep posting it. So it can be the difference of like 2 minutes to post it versus like 10 minutes to post it. So that's something that I definitely recommend too. As well as just having like a response. So when somebody inquires for one of our suites, of course, I'm going to personalize a little bit depending on what they're asking me, but I'm always going to ask them like the same sort of 5 questions. So when do you want to take possession? Who's going to be living there? Do you have any kids or pets? Long-term, like do you have a long-term job? How long Calgary for? Just simple things like that. So I just have a write-up on my notepad, just copy and paste that in so it saves me from typing it out every single time.
Yeah, and I do the exact same thing. So I use Google Keep. I've got the dozen questions, a little bit more than a dozen, but all my questions pre-laid out. I have a little intro blurb, but the same thing. I go, hi, so-and-so, you inquired about this one question. I answer the one question, and then I say, hey, so I can save you time, make sure it's a good fit before I book your viewing. I don't want to waste your time. Please answer these questions. I kind of throw it back from their perspective that I'm protecting their time. Hopefully, I encourage them to go and fill out the question. I also use a filter too, because I'm sure Terrin and Chris, both of you guys, and say, how often do you guys get a request for a viewing? They say, is it available? Or can I come tomorrow and look at it, or can I come today and look at it, and you haven't got any information on, right? You always get those kind of inquiries. So I always push back with the questions, and if they take the time to fill it out, because it would probably take 5 or 10 minutes, because I do ask a fair number of questions, then you actually know they're generally interested in the property. But if someone's kind of a tire kick and they just say, hey, is it available, or I come by tomorrow, and you throw the questions at them and they don't respond, well, then you just saved your time from going to a no-show probably.
Yeah. That's the same thing too, with always making sure that they text you an hour before their viewing, right? So
love it. Yeah.
I always do that. I always try and line them up kind of 15 minutes apart, so I know that I don't have to drive 3-4 times. I set them up 15 minutes apart all on the same night, and make sure that they text me before that they're going there, so I know that they're serious about coming.
I love it. Yeah, same system. I call it tea time bookings. You land them about back to back, and the kind of the cool thing with it is you get this really good third-party validation, right? So if they usually ask, oh, have you had any other people interested? Do you have other people looking at your property? But if they're waiting to get in the property because maybe one viewing took a little bit longer, and they see 2 people walk out the door as they walk in, well, then now there's that third-party kind of excitement, or if they especially get a good first impression and they walk into the house, you might have just pushed them over the fence of getting that application in that night, as opposed to if they hum and haw and everything else, you just get better traction.
Yeah, absolutely.
Cool. Yeah. Chris, we got some questions coming in, or what do you see here?
There's a couple questions. Actually, I'm just working on a couple in the background here.
Okay, so, you keep doing what you're doing. I like Terrin, I totally agree with you. Like those are great tips just to kind of manage your time. And what I do as well, I do the same thing. I ask for a text depending on how far I'm away, an hour and a half before, confirm it. And I also say if I don't get that text, I consider the appointment canceled, and I don't show up. And I tell people on the phone with that, and they're like, oh yeah, that makes sense. Just I want to be respectful of the time, but it still happens. All the time. People just don't show up. I guess it is what it is. But I find, and maybe Terrin, I'll get your opinion on this too. I find the further I book someone in advance, 24 hours a day in advance to 2 days to 3 days, maybe to the weekend if it's like Monday, the further you stretch out that viewing, they seem less likely to commit to it. That's just my personal experience. Do you see the same thing?
Yeah, absolutely. I try and do it kind of the next day, next 2 days if possible. But again, I also try and line them up back to back. So I'm not just going there for one person. I'm going there for hopefully 2-3 people, right? Because, our furthest suite is probably 20 minutes away, which isn't that long, but it's still, you know, a 2-hour process, right? To go drive there and back plus being time.
Yeah.
So
turn on lights, make the place look nice, maybe open some windows, all that
Yeah.
kind of stuff. Yeah, and I know you like myself, you've got kids, young kids, so time is valuable.
absolutely, yeah. So I don't spend more time away from him if I don't have to. So
Yeah, totally. Cool. Awesome. All right. Well, let's get into the questions, Chris. I threw some up on a page, but I haven't pulled them up yet. So if you want to queue up the first question, I'll get my questions organized and we'll all go around robin at them.
Okay. So one of the questions that we came up, I was just watching. Helen was asking, says, "What's the difference between the RTDRS and regular court?" And Don Gray, who's one of our legal guys who helps people get through the RTDS or whatever, he explained. He says it's pretty much the same thing. It's just one is, you know, it's still like a small claim type court, but one is held by a court is held by a judge, and the other is held by a designate, sort of like almost like a, what would you call him, that person? I just can't think of the name of them right off the head.
Arbitrator?
Arbitrator, yeah.
Cool.
Sorry, Terrin, we couldn't hear you.
I was saying justice of the peace, but I guess.
Yeah, no, they're definitely not that. But anyway, so I was just texting to Rob Bond, and who does a lot in Red Deer. And I said, which would you pick? He says he'd go to court every single time. And I have to agree with him. Getting into the court, a provincial court, to deal with getting your renters out and stuff, you're going to have a little bit more awarded to you in costs and other things where you're not in the RTDRS. They're reluctant to give costs on certain things, where a judge will go, yeah, you can have that. Yeah, you can have that. And I'm finding that the RTDRS2 don't necessarily always follow the procedure, the rule of law when you're in there, and it gets frustrating when you're trying to present something, and sometimes there's a little bit of a chip or an edge. And to answer that question, I would pick provincial court each time over the RTDRS. However, with COVID being on, to be able to sit at home and not have to go into a courtroom, you may prefer that angle too. So
yeah, you can do phone call to RTDRS right now, which is
great. If it's just a matter of getting somebody out, and hopefully there's not too much damage, that's important to get in quickly. You may have to go back a second time for the damages anyhow, as you would for court, because you just don't know what you're walking into, right?
Totally.
Yeah.
Cool.
So I hope that answers the question. What else? What do you got for questions collected?
Sure. Do you have any more to add on that, Terrin? Chris, I think you did a good job.
Well, thanks, buddy.
I would agree. To be honest, like COVID or not, it's just a lot easier to do a phone call hearing when sometimes, I think our last one was like 10 minutes. So to drive downtown, park, go in, and so forth, it's just easier. If you have a solid case, if you built your evidence,
yeah,
I think it just saves, again, your time management, right? Trying to maximize your time. So.
Yeah, I have to absolutely agree with you. If it's a straightforward thing, RTDRS, and you can sit at home with coffee and do it, absolutely. Yeah. But if you got a whole bunch of wonky stuff going on that you have to prepare for, and you have to explain, I would pick a judge over the RTDRS, because they are. I went through one, and they just refused to give costs on certain things, and they were reasonable costs, but they said, no, we're only giving you this. No, and it's just. Anyway, that was a little bit frustrating, because I knew would be more successful on the other side, but we needed to get speed in versus or during COVID versus the wait. So
yeah, so great takeaway. If you've got clear cut eviction, it's black and white. You've done your documentation, you've got your evidence. Go down the RTDS route. You'll get a quicker judgment. You'll move quicker, and you can do it remotely right now over the phone. If there's some gray area, you want someone who's a little more trained in the law, a judge, as Chris has said, you'll probably get a more fair result.
Yeah. Helen's just chimed in here with some information where she had a judge in the provincial court that wasn't prepared and didn't look things over. You're going to run into that, and it's unfortunate that professionals aren't taking care of to taking care of your case a bit better. But I don't know. That's just unfortunately the luck of the draw.
Yeah, totally. Okay. I've got a fun one here. I'm kind of excited about this one because I've actually never seen a situation before. So I have someone, I pulled it actually from another landlording group. A tenant asked about, before they moved in, about pets. So they said the landlord agreed to it. They wrote pet approval in the lease, and then there'd be a pet fee once the tenant found a pet. Well, fast forward a year and a half later, the landlord discovers there's a pet in the property and they were never notified. However, written in the lease, there's a monthly pet fee. So how would you guys go about handling this situation? Let's say, just for argument's sake, they're a year behind on a pet fee of, $30. So what is that? That's 300
400 bucks.
$400? Okay.
Yeah, 400 bucks. Yeah.
Yeah. Well, anyways, an amount of money. So it's written to lease that you would give them approval once they found a pet and they were supposed to contact you, and they didn't do that. So how would you guys handle that amount owing, or how would you handle the situation in general?
I don't know. I guess what's your relationship with them? Is it good? Tell them, say, hey, if you can get the starting point, say, you guys owe me the pet fee. It's right there. And they say, well, I'm not paying it. And you get into, and all of a sudden your relationship goes sideways. I guess is there an eviction? Is there grounds for an eviction? Let's throw that out there.
Yeah.
Terrin, what do you think, Terrin?
Yeah.
I would say it's tenant dependent. So if I think these are a great tenant, they're taking great care of my property, they're paying rent on time, etc., I would probably either start it going forward, or I would say, okay, we've had it there for a year. It's supposed to be $30 a month. Why don't we meet in the middle and we'll split it, right? So I'll only charge you half of the pet fee that's owing, and then going forward, this is what you'll be paying. So I think it's situation dependent. If it's not a good tenant and you kind of want to maybe get rid of them anyways, then it's a way to, it's a breach of their lease, right? So either pay that balance in full, or you could file for an eviction.
I personally think that, the pet issue is arguable, and really, can you evict on that? I would say not. And really, do you want to? You've already said that they could have a pet. There's some communication issue there. You know what?
Yeah,
the eviction.
I don't have the full story from the post. I don't know if the landlord was negligent in doing maybe some, periodic inspections of the property, because in their post it says fast forward to a year and a half later. That's a long time. That's already one lease renewal in place. So if it's a typical lease renewal, 1-year lease renewals, I totally agree with Terrin. I think it really is tenant dependent. If you've got a good relationship and this is an oversight, or maybe there was a miscommunication where they thought they could just go and get the pet and it was already understood. What I would probably do to maintain the good relationship is I'd be raising their rent the next year to make up that difference, but I wouldn't charge them the pet fee. So on the surface, they look like they got the win, but you're still getting your numbers back on the next lease renewal if you plan on keeping them. If they're maybe a little more difficult and there's other things they push you around with, this is the point where you've got to be clear in your communication, because you got to set expectations, right? And if this is another thing that they can get away with, they're gonna press you in other items probably coming with that property, and likely cause you more headaches down the road.
Yeah, I would agree. I mean, it's kind of a respect thing, right? Like if you are not respecting me enough to tell me about it, it just kind of it breaks that level, that crosses that boundary, it breaks that level of trust, and just kind of dampens the relationship. So at the end of the day, it's still our property, right? That we purchased, we invested in, we're maintaining, and we're trying to make it, a place for you to live and enjoy. But there has to be a respect for us too, landlords.
It's a business, hands down, for sure. Cool.
Well, Mackenzie, let's grab one more question. We're already over an hour, and we're going to start losing people. So, and I got to go. I'm going to go whack some golf balls here. So.
Oh, okay. Well, I got some. Chris, you got a question lined up, or?
No, I just thought you had something on your list there. So.
Yeah, it takes me about 2 seconds.
Oh, wait, no, let's go to that last question right now. Someone just popped it up, so it kind of spins off of what we're talking. You want to put that last question up?
Okay.
Sir.
Pet fees, common practice. Since joining this group, I've seen much about it. We've been a landlord of a real property for 28 years and never utilized this. would there be a rationale for charging it? So rule, you know, I'm all city rentals, just to be kind of clear. I'm all in Calgary. Terrin, I assume you're the same as well. You said you're all within a 20-minute drive, all city. Rule be, I guess it really depends how the property's set up, and if you're, you know, acreage or farm or quite what you're renting out there. If is your property set up to take certain animals, livestock? If it is, and that would be a competitive advantage. If it depends, and again, it depends what the market's willing to bear. So right now in Calgary, it's been getting better over the last 3 months. I've raised rents a bit. So, you know, and I was doing I was doing pets before, just because it opened up to having a bigger renter pool or a tenant pool to market my product to, right? So, but yeah, I would love to have that conversation with you offline, or maybe we need to get. I know we had Renee on one of our first episodes. She was great. She's got a couple of rural properties. That would be a great conversation to have on how it plays, because you've been doing it for 28 years and you'd never done it. Acreage, no livestock, just house pets. Yeah, I mean, it comes down to, you know, I know I got some family out by Penhold and out by Red Deer and whatnot, and they all have dogs. So that might be something, if you have it set up, that you can have an advantage for, or if there's in a position to charge for some money, or maybe because that's just everyone's got dogs. That's kind of the pet you must allow to have a good renter market out there or tenants to select from.
Helen, that's a question from Helen. Yeah, Helen, I think in the rural, you just weigh it out. You got to remember, pets do cause a lot of damage, a lot of hair, a lot of things like that. So that little extra is to compensate you for anything you have to do when they leave. However, you have to wait out. In the cities who have places, for me, pet fees are a must now. And I've done since as I've progressed, and even from learning from being on the page and what people are doing, is I've incorporated it into my program. So
yeah. I realized I didn't really actually answer her question. So she's like, what would be the rationale to charge it? So she's looking how to frame the conversation.
Well, I think I kind of answered that. It's damage issues and cleaning furnaces and all that stuff. So with the hair,
there's more wear and tear on a property that has pets in it than there is without it.
Yeah, increased maintenance costs, increased wear and tear. I just did a renewal, and my tenant asked for approval for a pet. I said, "Yep, sure, no problem." And then he went through and he said, "Well, if I'm going to pay a pet fee, I want you to remove this clause on my lease for, I can charge for damages, basically." I said, "No, I can't do that, because here's why. The increased pet fee, or the pet fees that cover the increased wear and tear, and I'm going to have bills. I'm going to have to replace flooring sooner. The yards, especially landscape, is not cheap. If you're going to be turning over and you have someone else moving into the property and there's yellow stains everywhere, or they dug holes, that takes quite a bit of money to maintain that." But the second part, I said, well, I still have to have that clause in that lease to protect me, because I'm protecting myself from negligence. So, Mr. Tenant, I know you won't do it. You've been good. I've had you. This is his third renewal with me. He's been great. I said, I have it just in case someone ignores their pet. They live in the property for a long time. It just, it pees and poops inside the house, and or it tears it up because it's been locked in the house all day long, and it starts chewing on doors and walls because it's stir crazy. I have to protect myself against that situation. That's why I still have in my lease, as well as I charge a pet fee.
Yeah.
And making sure that it's worded as pet fee and not a pet deposit too.
Yeah. Good point. I just non-refundable. So if you use the word deposit, that could infer it's refundable. So you're saying the word is really important. Yeah, a good point, Terrin. Totally. And I even seen some people take, and so I'm going to start doing this. I've always been taking like a monthly pet fee, so $35, $45, whatever it's been. And I've had my last tenants, they were in for 1 year and they moved out. I think next time I'd do it, I'd probably take an upfront fee of like $150, and then do my reoccurring monthly fee as well. And maybe I'd make that monthly fee a little bit lower, but I just want a little bit more money up front, because I've had some tenants move out quickly where I thought I'd have them for more than a year, and I let them have pets as well. So
last question, we'll just finish off with this one here. If you can put Leanne, the very last question came up, and I can answer that quickly for you, Leanne. She says here, can you charge a pet fee halfway through the lease? Tenant informed us of a pet when the lease was signed, but we didn't think of charging a fee at the time.
Have you already provided approval for the pet?
Yeah, well, that's the way I read this. She has applied. Yeah, they were informed. It says here she was informed of a pet when the lease was signed, but didn't think of charging it. So when your lease comes up, Leanne, you're going to be at a point where you're either going to renew with them or you're going to have them move on. That renewal will come with your changes at that point. So if you're halfway through, so I'm assuming it's September. So give March, I guess, of next year will be your year end. So whatever it is, just come with your new lease, your new agreement, and what your new fees will be, and just let them know ahead of time what you're planning on doing. If they don't accept it, then they're moving out, and you're finding a new renter. So,
and if they've already been in the property for a trial period, it looks like they've been in the property 3 or 6 months with the pet, and you've done your inspections, you can see how they're treating the property. And if it's not going well or not going as well as you hope, you do see some increased wear and tear, you can point it out and say, this is why we need to have a pet fee, and I'm going to move to this model going forward. Or you can, I always third party it, I'd be like, I had another property, I had a really bad experience, and on my renewal, this is the new system I'm using just to protect myself. And it doesn't even have to be your story, it could be someone else's story. I do that a lot as well.
If you're adding in new fees on a renewal, do you have to give 90 days notice?
Well, so you can't raise rent more than once every 365 days. So if you structure a term contract, okay, so let's say you're 6 months in on a 1-year lease, or let's say you're 9 months in, you're 3/4 of the way, and you want to renew them quickly for another 1 year. If you start that new lease overlapping and you cancel the old one, you can't raise the rent. But if you tack it on and it's just continuous at the 12-month mark, yes, you can raise the rent.
You can. So my question to you is, can you raise the rent without notice at the end of a lease? Can you just pop it in front of them and say, here's what it's going to be on the next first of the next month?
I guess you could do that, but you wouldn't, like, that just doesn't leave a good taste in anyone's mouth. You want to have good communication, and in theory, you should be going to these tenants between the second and the third month to see where they're at, gauge their interest, because if they're not biting and you throw a number at them, you talk to them, they say no, thank you, you now have that 2-month lead time to find the next tenant, and you're not scrambling in the last month.
Yeah, Don commented it's not a rent raise, it's a fee. But again, my argument there is that you're introducing a new cost, and you need. I would be giving proper notice that I would give 90 days notice. Now that you know this information now, and you're going to charge a new fee, give you 90 days notice that there will be a fee for a pet, then you're covered. There's no arguments, and everybody knows going forward.
Yeah. So at the third month, on the third month remaining on the lease, position this, write them, do some communication, have that conversation, and then 2 weeks later, at the 2.5-month mark, or whatever, a week later, see where they're at, and you'll know very quickly if they're interested or not. And then you're in a position to get your place rented out with time on your hands.
There you go. Well, I think you're going to call it, or what? What are you going to do?
I got a couple more questions. I kind of want to go a little bit further. We still got 14 people watching right now, so I'm kind of motivated to keep going. I know, Terrin, you got kids at home like myself. What do you think? You got time for another question, or do you want to?
Yeah, I got a few more minutes for sure.
All right, you're still free. Dad's taking care of the kids right now. Love it.
Heard the mummy scream yet, so.
Oh yeah, it was getting the show started was challenging for me.
The comment was, you don't need the 3 months notice and no reason to give it. I appreciate what that person's saying. However, you need to run the business with ethics and with open communications. To dump $100 pet fee or a $50 pet fee on somebody and here's your new release. I'm going to go back to run your business with proper etiquette and say, look, in 90 days, we have the pet. I know this wasn't discussed, but this is where we're going from here. And Mackenzie explained, these are things that are up front. It's additional wear and tear. So do you have to give notice? Well, no. But do you want to give notice? Yeah, because you want to maintain good relationships. So, right? So,
yeah, treating each other with respect, right? And it goes both ways. So
That's right. That's right. So
Cool. So I've got, I do have 2 more questions, but I'll let you, Terrin, you pick. So question 1 is, first time renting our home. We've got people lined up for September 1st. They're asking to move in a bit early. They want to move in some furniture, rugs, tables, etc. a few days early. Is there anything I should be aware of to allow them to do this? So that's question 1. The other question we can talk about is a gal says she's about to wrap up a lease, and she was in the property 2 weeks ago, and there's an overwhelming, really bad pet smell in the kitchen, urine, something of that nature. She's worried about how she should document it on her move-out inspection if that smell is still present when she does her move-out inspection 2 weeks later. So which question do you want to take? Falls in your court.
well, I feel bad. I don't want to leave either of them hanging. I can try and get through them both really quickly, I guess. But
Sure. Yeah. I don't know. Okay. Let's tackle. You pick one. Which one are we gonna do first?
Well, so first of all, like moving in September 1st. So what I would do is we have on the occasion, especially if it's like, the 29th or whatever falls on the weekend before, we will let them move in a couple days early. However, the lease, like the first month rent has to be paid, damage has to be paid, and the lease and the walkthrough have to be all done. And then we will just put the possession date as the 29th, 28th, whatever it may be. And we'll just give them, a couple days of a freebie. But you have to make sure that you have all of your, ducks in a row. So make sure you have both payments, make sure you have all your paperwork signed, just to make sure that you're still protecting yourself, right? So we never give keys without paperwork or full payments.
Yeah, that's like nail on the head. That's exactly, that was my biggest take on the question too, is if you're going to let someone in early, that's totally fine, but make sure you get your inspection done and make sure first month's rent and that damage deposit is in possession in your bank account, not a check in your hand, before you give those keys or the access to that property. And depending on the market, if it's we're kind of definitely a balanced market right now for Calgary, but you could prorate if you give them next week, maybe you prorate them, or maybe it's just a move-in incentive. Hey, you get the first week for free or something like that.
Yeah.
And what I do as well too, so if you are going to prorate or you are going to charge for it, I still collect 1 full month of rent and the damage deposit before I take possession. Then I make their second month whatever that prorated amount was. So if it's only 2 weeks, then I charge half rent for the second month. Because I don't want someone to move in on me. They've only paid a little bit of amount, and then if it goes sideways, I'm knocking wood, it hasn't yet, but I want to put myself in a position of strength. So I want to move those smaller costs to the next month, or maybe you might even put down at the end of the lease, so they're motivated to stick around to the whole term of the lease.
Yeah, I mean, that actually, just to touch on that, but with for an incentive as well, just as a little side note, if you are going to offer an incentive, I always put it onto the last month of my lease too, because that way it ensures that they're going to stay for that full term, and you're not giving a half month free, and then you might lose that if they don't stay for the full term of the lease. Exactly.
Love it.
Yeah.
Incentive. That's a really good way to incentivize your lease. Chris, any thoughts on that?
I'm good.
This guy's streamlined. Let's do this. Okay. Next question, super quick.
I'm Mackenzie. Sorry to leave you short here, but I got to check out on you here.
Okay.
I got,
you head out.
Things going. You and Terrin are it.
Okay. Thanks, Chris.
See you guys. Have a great one. Look after yourselves out there. Cheers, everybody.
Bye.
All right. And then there's 2. We still got 15 people on, so I think we're digging okay. And people let us know if we need to go or whatnot. Well, the proof will be in the pudding. If they drop off the show, we'll see the numbers go down. But so yeah, I'll hop right to the next question then. So a tenant. Yeah, so this goes back with the pet smell, right? So a gal was looking at a property. She's wrapping up a lease. She was in prior to the end of the lease, about the last month. She noticed it was in very good condition. There was really bad pet smells and urine in the kitchen. So she's asking, if I come back in 2 weeks to do my move-out inspection, and I do see that there's urine or some other, let's say, pet smells in the kitchen. She's asking, how do I document it? So Terrin, I'll let you do your first take on how you'd handle that situation, and I'll riff off what you say.
To be honest, like I haven't ever had to deal with that before, where we've had, without it being a clear cut situation, prior, I know my husband, prior when he first started, had somebody that had 6 dogs, and it was just a big mess.
Yeah.
I haven't had to deal with that, luckily. What would I do in that situation? I mean, it would be really challenging, I think, to, document that as a smell. I've definitely marked it on the paperwork.
Yeah.
And then, they can either agree or they don't agree on your move out inspection that, this is true. I mean, you would hope that they would be like, yes, you can smell this. But I don't know. What do you think? Like, how do you document a smell?
I've got 2 ways. So the first thing I've been doing a little while now is I do video inspections. So I definitely still do the paper form because it's kind of a nice little summary. It's easy to read. But I do a full video the entire time they're in the property when we do our move inspection and when we do our move out inspection. So if I'm walking through the house and I hit one room, I'm like, oh, that smells like a litter box or whatever that thing is. I'll have that conversation, capture it on film, and then like, yeah, I know. Johnny and Frank, those 2 cats, they're stinky and, they have a hormone problem. That's why it smells really bad. Get some sort of verbal conversation going that they're admitting to that's existing. That's the one thing. The other way you could do it if you're just doing, well, I would always do the video walkthrough. That's my pro tip on that. But definitely document as well. But then go get a third-party thing. So have cleaners come out and take a look at the property and look what it would cost to have it cleaned. So now you have your move out inspection. You've documented there's a really strong smell from the cat, and then you have a cleaner from, like, I don't know, Rams Upholstery or whoever you might use, saying it's going to cost you $200 or $300 to steam clean that floor. And you've got that third-party validation backing up. It's not just you saying that.
Yeah, we've had to do that for people that have smoked in our suites. Bringing in a third-party sort of
neutralizer air machines, whatever they're called.
Yeah, so we've had that documentation, but not for pet urine. Knock on wood.
Yeah, definitely. Yeah. All right, so yeah, I've got some comments. I'm going to throw them up in the group here. So it says, yeah, I sent an email to the tenant and noted in the email advising the tenant to ensure they corrected before the outgoing report. Perfect. And you know what I like about that too? So there's 2 things at play here. So one, use whatever means of communication you've been using. Email is the best because it's easy to print. You can use text. It's just a little bit harder to download the text off your phone and document them in a PDF. Still can be done. But if that's the normal means of communication, they're always responsive. Fire off an email, put it in writing, and if they respond to it, then they admit it's there and they say, yeah, I'll see what I can do, or you've put the onus on them to now talk about that subject. So when you get that back in writing, you've got now confirmation that it is an existing problem.
Yeah, absolutely. So mention that 2 weeks before, that she's done that. So yeah, have that documentation available.
Yeah, and need to have the form signed. That's what is allowed in court. So this is definitely talking about the move-in inspection. On the ones that I use, they're really good. There's a super standard form from the CRRA, Calgary Residential Rental Association. There is 3 sections on the form. You know what? I'm going to grab it right now because we've talked about this before, but it's super important. Is because you could have a tenant refuse, right? So it says right here. So here's the move out. It says on the move out report, there's a statement part here. It says, number 1, the inspection on the premise was conducted on this date by this landlord or agent and by this tenant or agent. And it has the landlord signature, and then the number 2 says this inspection was conducted on same date and with the same landlord without the tenant or the tenant's agent being present, and then you sign it. And then the tenant also has a choice to sign the form that says this move-out inspection fairly represents the condition of the rental premise, or they disagree, and there's another space to sign out when they disagree. So there's documentation for that, and they can still sign in the position they take, but you should get them to sign for sure. But I know if they refuse to show up to the move-out inspection, I've heard some people deal with that right now because of COVID. Well, people are using that as an excuse. But they have to show up, and I think you have to give them
3.
Is it 3? Okay, good. I was going to say 2, but you have to give them 3 opportunities at different days and different times to be present for the move-out inspection. And if they don't show up for all 3, then you're allowed to perform the inspection without the tenant present.
Yeah. Yeah. Of course, you always want to have it signed, but I have had instances where it's gone badly and they refuse to sign anything, and you just try and do what you can, but at the end of the day, you want to make sure that you get the keys so you have the possession of your property back in your hands.
Cool. Love it. Awesome. Well, let's wrap it up. Terrin, thank you so much for giving your time this evening. I know you're busy with the kids, as I can hear my babysitter doing quite well right now. So yeah, just I always like to throw a little bit of time and give you a plug. So in return for spending your time with us tonight, you got a passion project? Is there a business, a charity that you want to make mention? What's important to you that you want to share with our audience?
I just wanted to say, I really love this support group for everybody. I've learned a lot over the years of being a landlord, and I've invited other newer landlords to this group just so they can learn more. If you have a question, whether it's regarding the property, investing in property, landlording, don't hesitate to reach out. I'm here to help. I really love helping people and helping themselves get them set up for success in the long term. So I've even helped, people that are buying in Edmonton that I'm not getting any benefit from it. I'm just trying to help them, give them the information that they need when purchasing something. So I've reached out to Edmonton realtors that I know and just answered their question, whether it's a comp or something like that. So I'm here to help and just, support people. And I'm a very firm believer in people helping people will just make the world a better place. And in turn, it'll come back.
Absolutely. That is totally the premise of this group, this community. You're banging on the head, Terrin. So that's probably why you're a great fit and why we're having you on the show. So thank you for doing that and building the community. And everyone, yeah, by all means, keep asking questions. It's a complex business. You're managing relationships with expensive assets. There's so many different challenges that we all deal with on a daily basis. So keep asking those questions. And the power of this community is you've got a lot of experience that can come out and help you through the group. So that's another Alberta Landlord Shoptalk show in the books, the only show dedicated to landlording in Alberta. Terrin, thank you for being our guest tonight. And folks, we'll see you guys next Wednesday.
All right. Good night.
Good night.